So let's turn over to civil liability for, this is primary market disclosure. So these are the liabilities that we've had forever. This is in a prospectus, a takeover bid, a director circular, and offering memorandum. And the Act sets out defenses. So obviously if a purchaser had knowledge of the misrepresentation, if the document was filed without the consent of the director or officer, and they give notice of that, or the document's withdrawn, there's some expert reliance defenses, and then the main one that people look at are due diligence, and again, it's sort of a test of reasonable investigation, reasonable grounds, you know, and then and there are also some defenses around forward-looking information. The bigger one that's newer, and this is where we see the class actions today, is for secondary market disclosure. These rules came into force December 31 of 2005. And in this area, there's sort of a distinction between core documents and non-core documents, and then there's also the concept of public oral statements. So there's a liability for misrepresentation, and then there's also liability for failure to make timely disclosure of a material change. And there are differing burdens of proof. The plaintiff has a higher burden of proof when they're dealing with a non-core document or a public oral statement. But the burden of proof is less, so they don't have to prove the case for a core document. So you got to think about what are those core documents, and if you're trying to sort of decide how to spend your time, you're going to, as a board and management, you're going to focus on those core documents, because that's where the hardest, the most liability is going to arise. There are also potential liability limits, and I think when these came out, people were really hoping that this would sort of make the difference. For an issuer, it was the greater of 5% of market cap, or $1 million, and for director or officer, it was a greater of $25,000 or 50% of their compensation. The fact is that these limits are kind of useless, because in every claim they allege, and then they have to prove, and we'll see if anybody's ever successful, but if they can prove that the director authorized, permitted, or acquiesced, then the caps are off. So that's a challenge. In terms of the defenses, there's a long list of them. Again, similar to the primary market ones, the purchaser has knowledge of misrepresentation. There's the due diligence defense, reasonable investigation, and in the Act, it actually sets out a list of factors for the court to consider. I think the most important ones that I would raise are that the party had a system designed to help the company meet its disclosure obligations. So court will consider that. That there was, it was reasonable in the circumstances for the directors and officers to rely on those systems. So again, that's what the court's going to be looking at. And lastly, the other factor that I think is quite important is the role of the person and their responsibility. So when they're looking at an actual director or officer and saying, does that person have liability, they're going to look at that role and what they did. Other defenses include, that you did a confidential disclosure, and I will admit, since 2005, we actually do see these from time to time, confidential material change reports. Forward-looking information, that's an important one. There's a prescribed test on how you get yourself into that defense. People like to just throw the boilerplate at the end of the document, and they don't really pay attention to, what it says and the level of detail that's in it. And it's always this struggle. But to get the benefit of the defense, the first thing is that it's got to be, reasonable. The statement that you've made. And then you've got to talk about all of the risk factors and the assumptions that you've made around that forward-looking statement. And then the sort of other element to it, which again I have trouble with, is the proximity. Like that your cautionary language has to be proximate to the actual forward-looking statement. So when you just dump a piece of boilerplate at the end of the document, like you're not really dealing with proximity there. So trying to remind people either at the beginning of the document or at the main part of the document, if you've got an Outlook section in your document, you might want to actually have a very clear cross-reference. This section contains forward-looking statements. Please see our cautionary language. When you get to the cautionary language, you need to focus on what are the kinds of assumptions that you're making in making those statements, and you've got to focus on, what are the risk factors. And it shouldn't be like basic boilerplate and too short. It really actually should focus in on the actual, look at the statements that you've made. They're forward-looking, and then figure that out. Like, what are the risks and assumptions? Somebody should do that initial analysis to come up with your main cautionary statement. And then subsequently, you should look at, if you're disclosing a transaction, that hasn't closed yet, you might want to throw in the caution that, we're assuming that it will close, and the risk is that it doesn't, for regulatory approval reasons or whatever. So it's just, if you're trying to rely on that as a defense, then you want to make sure that you comply with the obligations around that.
Kathleen, what if a client calls you up and says, look, I'm sitting on a board, there's 7 guys on our board, we work on a consensus basis, they're planning to disclose something that I think is incomplete, and I'm not really comfortable with it. I'm not really sure what to do because I think I'm going to be brought along as part of the pack. Is the only option to ask the board to minute the fact that, would that help you if you minted the fact that you thought your disclosure should have been broader? Do you walk with your feet? I mean, what do you do in a situation where you're sort of the lone ranger?
Yeah.
Tell a client?
I mean, why don't we skip forward to, there is one thing here that's a corrective action. It doesn't really help you in the board situation, right? This is more directed at influential persons and officers. But where you go to the board and you say that you have an issue, this needs to be disclosed, for example. If they don't do anything, then after 2 days you could go to the EOSC and you could tell them. But that's subject to, like, for example, a lawyer can't do that because we've got a professional duty of confidentiality, but there are other people who aren't bound by those professional rules. So that's one way if you're not the actual board. But let's just focus, maybe I'll just skip over. These were just examples of some current cases. There are people out there who are prepared to fund litigation, okay? And so there is a very clear set of rules and case law around the fact that can work. So just because your plaintiff group doesn't seem to have money, don't assume that they're not going to be able to pursue a claim against the company, because there are people out there who are looking for these cases and who are funding them, and it's been considered viable.